Today was all about time. In the appeal of Erin Patterson, the prosecution set out to say why they say she should spend more time in prison. For them, there's only one option. She should die behind bars. I'm Brooke Grabert-Craig, and this is The Mushroom Cook. So Laura, it was day 2 of the appeal today. Did Erin Patterson appear in court?
She did appear via video link again. It probably would have been a bit of a surprise if she decided today to appear in court. But today it appeared that the camera angle was a little bit different. We were able to see a little bit more at the bottom of her screen in the teleconference room. We could see that she had a laptop in front of her. And at times during the appeal hearing today, we could see that she was making some notes. And then at the end, I observed her pack up the laptop. I think she had a mouse with her as well and a couple of books. So by being in the teleconference room, she actually has a little bit of space in front of her to lay everything out so she can follow along while her lawyers are making submissions and when the prosecution are making their submissions as well. And there might be a conference she has with her lawyers at the end of the day that could have happened yesterday where they unpack a little bit about how the appeal went.
And can you talk our listeners through what actually happened in court today?
At the end of yesterday's episode, we touched on the fact that the prosecution only had a chance to respond to 2 of the 7 grounds of appeal put forward by the defence before the court was adjourned for the day. So today, Jeremy McWilliams, one of the Crown prosecutors, he returned again to finish his arguments. And there were 5 more grounds of appeal that he needed to touch on. So he started today with ground 3, and just like yesterday, I'll refer to my notes during this episode. But ground 3 concerned the photos of the foraged mushrooms on the SD card, the ones that the defence say should have been included in the trial during the prosecution case. That didn't happen. What ended up happening was Erin took the stand and the photos were tendered during her evidence. Today, Mr. McWilliams sort of unpacked the decision around why they couldn't go in during the prosecution case. He made it clear to the court that that was because the trial judge, Justice Christopher Beale, he said that he was not satisfied that those photos supported the possibility that Erin had a tendency to pick and eat foraged mushrooms. Tendency evidence, as the term suggests, is evidence that points to a tendency someone might have to do something. And what the tendency was here was a tendency to pick and eat foraged mushrooms. But Justice Beale didn't think it went as far as eating because the photos weren't exactly of the mushrooms on the stove, in a pan, being cut. They were more just on, I think we saw actually a Herald Sun newspaper laid out on the table during the trial in one of the photos and some mushrooms on top of it. And today Mr. McWilliams actually made that point. He was like, well, the photos on the SD card, they're not of mushrooms being sautéed in butter. I think he actually said the mushrooms there were raggedy mushrooms and that they wouldn't be the kind of mushrooms you'd use in a lovely mushroom ragu. So that was one of his arguments today about the 3rd ground of appeal. He then moved on to the 5th ground of appeal, just like they did on the defence side of things. They skipped over the 4th. And when it came to the 5th, this concerned the Crown prosecutor during the trial, Nanette Rogers. It concerned her cross-examination of Erin. The defence say that it was unfair and oppressive, and they made their arguments about that yesterday. And Mr. McWilliams was really quick to shut this one down today. He pretty much said none of the complaints the defence have with the cross-examination have any substance. There was quite a few that the defence had raised, but Mr. McWilliams said Dr. Rogers conducted herself fairly, she was thorough, and he said she acted in accordance with all of the rules.
And when he was saying all of this, what did the judges say back?
In comparison to yesterday, I will say that today the judges didn't ask as many questions. I think today was really just the barristers making their way through the rest of their submissions. There was less back and forth than last time, which for us journalists is a bit of a shame because it's really great when we have those interactions between the barristers and the judges. You can really get some good dialogue. But on this point, Mr. McWilliams really just did emphasise that they reject any suggestion that Dr. Rogers acted outside of the rules when she conducted her cross-examination. And just like he did yesterday, one of the judges presiding over this appeal, Justice Peter Kidd, said there wasn't too many issues raised at the time with Dr. Rogers' cross-examination by the defence team in the trial. And that's really something that they're going to have to consider here because all of these issues and complaints are being raised now, but the appeal judges have to consider, well, how was it actually dealt with at the time in the trial by the defence team?
Okay, let's move on to the sixth ground of appeal. Talk me through that one.
So this one, we got a really good quote out of Mr. McWilliams. At one stage when addressing the sixth ground, he said it was a Frankenstein of a ground. Ooh. So you can already see that this was a ground particularly that the prosecution took real issue with. And this ground is concerning now Dr. Rogers' closing address. And our listeners may remember yesterday, the defence say they have 35 issues with this closing address. Wow. And in their written submissions, you can actually see they've pinpointed them all out in very extreme detail. Mr. McWilliams said that 20 of those grounds weren't even touched on during the trial by Erin's defence barristers. And he went on to say that it was pretty clear that the defence made a forensic choice to, instead of raising issues with Justice Beale, they used their own closing address to address all of those issues they had with Dr. Rogers' address herself. They sort of used it to their advantage. Some would say this is a strategic decision where, you're now as the defence barrister presenting your case before the jury, closing your case, and you have an opportunity to respond to everything the prosecutor has just said to sort of knock down some arguments and really put forward your rebuttal. So that was the crux of Mr. Williams' submissions today on that point.
And when he's saying Frankenstein, what do you think that he means by that exactly?
I think that characterisation has something to do with the fact that there are 35 different parts of this. And he was talking about how some of those 35 are overlapping, some of them are also referable to other grounds of appeal, and they're sort of doubling up. So I think he was sort of suggesting it's just a little bit all over the place. It's not quite clear cut. It's all over the place, and the prosecution is saying we just don't agree with it at all. We say Dr. Rogers' closing address, there were no issues with it whatsoever.
Okay, talk me through the final two now, 4 and 7.
Yes, that's right. So the final two have sort of been grouped together here. These are the grounds of appeal that concern the Facebook evidence and the motive to kill. And what Mr. McWilliams said about this today was pretty much that the Facebook evidence was purely relationship evidence, is what he called it. He said it wasn't evidence of motive. It was more contextual. He said it was fairly orthodox evidence in the grand scheme of things, and all the arguments that were made about it were appropriate. He also really denied this idea that was put forward yesterday by the defence that there was this big change in the prosecution strategy and all of a sudden they had gone from not putting forward a motive to putting one forward in their closing address. He said, no, we take issue with that. That's not what we did. And then at that point, he really wrapped up all of his submissions. He had finally, we had gotten to grounds 4 and 7, and then he sort of took a step back and he said to the judges, this was an overwhelming case against Erin, and the convictions were inevitable in the face of all the evidence that was put before the jury, before telling them that Erin's appeal should ultimately fail.
And what was the vibe in the courtroom at the time?
Mr. McWilliams came to the end of his submissions here just before lunch. So I will say probably all of us were maybe itching for a bit of a break. It was quite cold in the courtroom today as well, or at least for me, I'll say. I was sitting in the media box quite close to the vents in the courtroom. So I remember I was quite cold, sort of almost shivering actually. But it was after lunch that we started dealing with the prosecution's appeal.
So what happened with that then?
Yes, so as a quick reminder, this appeal is against Erin's sentence, and this appeal is made on 2 grounds. The main ground of appeal is that they say this sentence was manifestly inadequate. That's the legal term that they're required to use in their grounds, but effectively they're saying it's not long enough, it's too short. And specifically, they've sort of framed that argument around the fact that Erin's non-parole period, so Erin has a non-parole period of 33 years, which means that after 33 years of imprisonment, she's allowed to apply for parole. Doesn't mean she'll get parole when she applies, but she is able to put forward that bid. They're saying that there shouldn't even be a non-parole period. They are saying for Erin it should be life is life and that she should have no prospect of ever getting out of prison.
I think we've touched on this on an episode before, but not having a non-parole period, is that rare?
That is extremely rare, especially I'd say for women in this country. If Erin is resentenced off the back of this appeal and they do get rid of her non-parole period, she will be only the second woman in Australia to be given life imprisonment without parole. So it's a very severe sentence. It does really take a lot for judges to decide that you don't get any option at freedom. That's not going to be ever something that's available to you. And I will say the only woman in Australia who is subject to a sentence of life imprisonment without parole, she's from New South Wales. Her name is Catherine Knight. What she was found to have done was stab her partner to death. She then skinned his body and cooked his head with the intention of feeding it to his children.
Shocking.
Yeah, so you can see, the severity and gravity a crime needs to sort of rise to for a court to decide that they're going to impose that sentence. But what the prosecution is saying in this case is Erin should get the same sentence. It should be life imprisonment without parole. But they've sort of hedged their bets and they've put forward another argument, which is, okay, if you don't agree with us on that and you believe Erin should have a non-parole period, they're saying that non-parole period should be higher.
And did they put a number on it?
Even in sentences, it's not really up to the lawyers or barristers to start putting or throwing numbers around for the judge to consider. They just make their arguments, but they're definitely saying that it should be higher.
And did the judges say much in this part of the hearing?
So there was quite a bit of discussion in terms of the prosecution appeal around one of their other grounds. And that concerns a ruling Justice Bill made when coming to deliver his sentence. He found that there was a substantial chance that Erin would be held in solitary confinement for years to come. So when a judge is required to deliver a sentence, they will make certain findings that they'll have to include in their sentence that's, written down. And this was one of those findings that he made. But the prosecution has taken a bit of issue with this, and they say there isn't a substantial chance of that. They also spoke about how they don't even agree that Erin is being held in solitary confinement. They
At the
said,
moment?
Yeah, they
Wow.
said the way we see her living conditions, we say it's not solitary confinement. The term is defined in some international rules. They're actually called the Nelson Mandela rules after the late South African president. And they set out the minimum standards for humane prison conditions. The defence said that if you spend more than 22 hours in your cell per day, it may be the case that you're experiencing solitary confinement. So it's the defence position that Erin is very much in those sorts of conditions. But the prosecution pointed to some of the facilities that she has access to while behind bars. They said she has access to a library,
Wow.
a leisure room. And we did hear some of this evidence during her pre-sentence hearing that there were some things she still has access to. Might not be every day, but on a weekly basis she might have a few hours where she can go to the library in her unit. But I will say at one point when these submissions were being made by the prosecution, I saw Erin not shake her head, but she appeared to sort of not agree with some of the things they were saying about her living conditions. She is the one experiencing them. But yes, it was very much her defence's position that she's currently in solitary confinement and they say she will be there for quite a while longer.
And was there anything else that the prosecution raised?
Yeah, the Director of Public Prosecutions, Brendan Kassane, who has been leading the appeal from the prosecution side the last 2 days, he had some really good quotes when talking about the seriousness of Erin's offending. And these comments were made in the context of him saying that she should not have a non-parole period at all. And he said today, and this is a direct quote, "This was offending of the utmost cruelty involving enormous betrayal. His Honour found it was planned for at least 2 weeks before the lunch, and that intention to kill was maintained for that period of time. His Honour referred to significant planning, the obtaining of a dehydrator, the identifying of the method, the concocting of an elaborate lie to bring the parties to lunch, and the arranging for the children to be away at the time." And then he said it was also of note that not only did Justice Beale impose life sentences for the murders of Don Patterson, Gail Patterson and Heather Wilkinson, he also imposed the maximum penalty for attempted murder for Ian Wilkinson, which is 25 years. So on every single count that Erin was facing, she got the maximum penalty. And he said that that really pointed to the fact that this was the worst case offending. That was a quote. And he was really, I think, not that the judges needed reminding of how serious this murder was, but I think really bringing home the fact that this is one of the most horrific murders that Victoria has ever seen. You know, technically speaking, it's a mass murder. It's the murder of 3 or more people, and in such circumstances that involved a serious, enormous betrayal of trust. The Pattersons and the Wilkinsons had no reason to believe that they wouldn't walk away from that lunch in one piece. So this was the submissions he made pretty much at the end of the day today, and I couldn't help but note that, only 1 or 2 rows behind him was Ian, sitting there again today with his loved ones. It's been great to see Ian, I must say. He's been catching up with some of the police officers who investigated the case. And I even saw him say hello to the tipstaff who ran the courtroom at Morwell. He bumped into him at the court today. So it's been nice to sort of see these people that, we spent so long sitting in court with during our time in Morwell. But, this is a very challenging time for him and his family because they're facing the prospect of potentially having to do this all over again. It remains to be seen what a retrial would exactly look like if that's what is to happen. But in some retrials, all the witnesses are called to give evidence again. In other cases, it might be sufficient to rely on the recordings of the evidence and they'll just replay that to the jury. But if, Erin has new defence barristers who come on board for the trial or the retrial, or if they're the same barristers she has now, they might want to put different questions to Simon Patterson and Ian.
And that would be so tough for the witnesses, especially people like Ian and other family members going through that trauma. Again, I just couldn't imagine the position that they're in, really.
Yeah, and, the appeal might fail and they might not be facing that prospect anymore, at least in the immediate future. But it's hard to feel like that's not something that is hanging over their heads. But at the end of today's hearing, as expected, the judges reserved their decision. It was going to be very, very unexpected if they decided today to just turn around and make a ruling. So it's now really a waiting game for all of us. We have to pretty much just wait for the daily court list to come out one day and it will say, tomorrow Court of Appeal will hand down their decision. Could be weeks, it could be months. There's a lot for them to consider, obviously, both with the defence appeal and the prosecution appeal. But time will tell.
And Laura, I have to ask you, I'm sure all of our listeners are wanting to know what you think. Do you think that Erin will win the appeal?
I'm not quite sure how to answer that question. I don't really want to speculate, but I will just say that in any criminal appeal, it is very hard to get your appeal up. Appeals aren't just granted every day in our courts. It is a very high bar. Here we have to have either one substantial miscarriage of justice or a fundamental irregularity. So if you really, think about it, it's actually not enough if there was a miscarriage of justice. It has to be substantial. And it's not enough if there's just an irregularity. It has to be a fundamental irregularity. So the law demands that it needs to be at that high bar, that high standard, because otherwise appeals would just be brought all the time by convicted criminals and the court wouldn't be able to keep up. Everyone would just go, oh, well, if it's as easy as, just writing up some paperwork, putting it in, hiring a lawyer to make an argument for me and I get a retrial or whatever it is, it just wouldn't be a sustainable way to run a criminal justice system. But yeah, like I said before, time will tell.
That's a very measured answer.
No, it is. I wish I could share my opinion, but it really is one where
you got to tell us how you really feel, though.
Well, like I said yesterday, it's not. I can say I think the appeal will fail, but at the same time, we have 3 judges on the Court of Appeal who have more than 100 years of experience. So who am I to even really think that I could be completely wrong? We could come back in a few weeks or a few months and she could win her appeal and we'll all be flawed. But I will say that she's up against it. I do think it will be difficult, but crazy things have happened.
Thanks so much, Laura. Until next time.
Until then.
Bye.